Good evening and welcome to our webinar this evening and our roundtable discussion, Finding Your Voice as a Parent in the Midst of the COVID Health Emergency and Crisis. We're here for empowering parents during this unprecedented road ahead after following an unprecedented road behind for the 2019 school year, which unfortunately is now continuing into this school year. We're a community of concerned parents and other professionals who are learning how to connect with one another to get through these difficult times. In the coming weeks and months ahead, we'll be moderating a series of webinars to address this unprecedented school year following the last unprecedented school year, where students are beginning in school or continuing with online or distance learning. We have topics that generally address the impact upon your child's special education journey, but we're going to take a detour this evening, given our topic for tonight. We are here to address your questions. We received a couple of questions prior to the webinar. We do encourage questions during the webinar. We encourage the use of the Q&A format at the bottom of your computer rather than the chat. The reason being this webinar is being recorded. I'm attorney Lawrence Berliner. I'm an attorney in the field of special education law. I have offices in Westport and Guilford. With me is our co-host, who's Jane Faherty, who's the director of the JumpStart program at the Stamford Jewish Community Center. And Jane is also an educational advocate. We also have two special guests tonight. In addition, we have Steve Ehrens, who's a financial planner, and attorney James Funnell, who's a special needs trust and estates attorney. I will get to them in a moment with a brief bio, and they can talk about themselves as Jane is as well. I have a disclaimer. As I mentioned before, this is a Zoom format that's being recorded. The information provided during this webinar does not constitute specific legal or financial advice to you or your family or your child's circumstances and should not be relied upon as such. The webinar does not establish an attorney-client relationship between myself, attorney Lawrence Berliner, and attorney James Funnell. It doesn't establish a financial partnership or relationship with Steve Ehrens. By signing up, you've agreed to receive information about future webinars from either the Stamford Jewish Community Center or the Law Office of Lawrence Berliner. This is a Zoom format. Zoom is a third-party provider and not an agent of or associated with the Stamford Jewish Community Center, myself, the Law Office of Lawrence Berliner, Steve Ehrens, or attorney Jim Funnell. We encourage questions, as I mentioned before, and we encourage the questions to be as general as possible. Because this is being recorded, we'd prefer to preserve your privacy and confidentiality as much as possible. We have just finished a tumultuous week with the COVID-19 virus cases in Connecticut and elsewhere spiking upwards. More schools have announced closures, full or partial closure, suspension of school reopening, continuation of hybrid. Some of the school districts, even today, were Shelton, Hamden, Fairfield, Westport, Bristol, other areas. Oh, I also forgot we had an election last week, but we're here to talk about schools. So without further ado, we have our two special guests, and I want to just give a brief biographical sketch, turn it over to Jane, James, and then Steve. Steve Ehrens is an expert in special needs financial planning. He's a CPA by license, practice, and experience. He specializes in financial planning for families of children who have special needs. He's a wealth management advisor and a passionate advocate, not only for his own child with special needs, but his clients as well. He's uniquely positioned to guide parents through the process of developing customized financial and estate plans for their family, a plan that's tailored to meet their child's future needs by ensuring that families look beyond one day at a time and empower their child with knowledge, optimism, wisdom, and the financial planning that he offers. Jim Funnell is an attorney in Westport with the law firm of Hernandez and Marcantonio, if I pronounced that correctly, yes. In Westport. His practice is limited to estate and trust planning, special needs planning in particular for family members with disabilities, including trust and estate administration. He's a fellow of the American College of Trust and Estate Council. He's a member of the executive committee of the Estate and Probate section of the Connecticut Bar Association. He's been peer reviewed, AV, which is a very special designation in the legal field by Martindale-Hubbell for over 20 years. And he's listed in the Best Lawyers of America. He's been named a Connecticut super lawyer each year since its inception in 2006. He's also been named a super lawyer. He's admitted to practice here in Connecticut, and those who are watching from Texas, he's also licensed to practice in Texas, because we do have people from other states participating. Our topics for tonight involve special needs and estate trust planning, and we are here to address questions and concerns, what kind of legal options are available, what kind of financial options are available. So without further ado, I'll let Jane Faherty take over, and then Jim and Steve could talk about themselves, and we can start with their outline, their presentation for this evening.
Thank you, Lawrence. So I think this is a really important topic for every parent that has a child, but particularly those that have children with disabilities. I predominantly work with children that are much younger, aged 2 to 3, but I do feel it's very important for the younger your child is, the better it is to start planning for their financial future. So I'd really, Stephen, if you could go first and just explain to those listening what it is that you do and how you work with families to support them in their estate planning from the financial perspective.
Thank you, Jane. So I have a 28-year-old daughter with special needs. I actually have twin daughters. And when my daughter Liz was born, I quickly realized that she was going to have a lifetime of disability in front of her. I then became aware that there were certain things that had to be done to prepare her for this lifetime of disability, especially financial and estate planning strategies, as well as governmental benefit and availability of resource options going forward. So I learned that there's not a lot of places to gather and find this information. So at that point, I realized that this would be a very good area for me to focus my attention. And as I navigated through this area, I realized that I was in a unique position as a parent, but also as a professional, where I would be able to work with families and help them the way I had helped myself. What I typically do is I'll meet with families. I'll try to get an understanding of their situation, as well as the situation relative to their child with special needs. We try to envision what the future of that child might be. Where might they live? What might they be able to do? What resources might they be able to access? Will they be living independently? Will they be living in a group home? And we try to quantify all of this and understand exactly what the financial future of that child might look like. Based on that and the family's resources and various different financial strategies, we try to create a plan so that mom and dad are going to be comfortable that when they are no longer here, that their special needs child is going to be in a financially secure position so that they will be able to continue, the child will be able to continue to have the life that that mom and dad would like them to have, even though they are no longer around to provide for them. So we're looking at mom and dad's resources. We're developing a plan for them through their retirement, through the end of their life. We're trying to develop a plan for their child with special needs. And then we try to integrate and implement that plan into the rest of that child's life. So that's pretty much what we do. And everybody's situation is different, and every child is different. And every child is different in terms of what they can and can't do, and what they may and may not be able to do in terms of earning income or accessing resources. And based on all these factors, we build a plan for the future of that child.
And then how do you interact with Jim? So Jim, what's your role within this? I know you're the legal arm, but what do you do once Stephen has the financial elements together?
Well, I think when I meet with parents, my job is to make sure that they have a clear understanding that they need to create two separate estate plans. There is the estate plan or financial safety net for the child with a disability. And then there's the traditional estate plan that all of us need, that makes sure that assets are directed where they need to go. For myself and my wife, at the death of the first, for her benefit, because she says I'm going to check out first, and at her later death for the benefit of the children. I think the key to understanding the second estate plan, the financial safety net for a child with a disability, is that we typically deploy that in the form of a trust. Even for a very high functioning child with a disability, we are typically using a trust that will at least protect an inheritance from that child's creditors, predators, and divorcing spouse. We want to make sure the safety net is available for that child only for the balance of their lives. And even for a high functioning child with disabilities, I think it's important to protect that child from predation. It's probably the single biggest issue that a high functioning child with a disability has. For more profound disabilities, we're interested in preserving that child's eligibility for need-based governmental benefits. And sort of the marquee there would be Medicaid. And another first encounter with public assistance programs might be SSI. Both of those ask two questions. The first is, do you have a disability? And the second is, are you rich? And if you're rich, you're expected to pay your own bills. And so our objective in estate planning is be sure that this child is not rich in the eyes of the governmental assistance programs. So that's sort of the framework that I want to set. Some of the things that I need parents to understand from the outset is that disinheriting a child with a disability and leaving it all to another child in hopes that that other child shows up is probably one of the worst plans that can be implemented. There is a legal structure that we can use to create a safety net for a child with a disability, and leaving assets to we'll call typical child, hoping that he or she will show up for their sibling, ignores the reality that bad things happen to good people. Mm-hmm. And if we pick on my daughter as a typical child, and she simply inherits everything, and I'm expecting she's going to show up with half for my son Jim. The problem there is that what if she dies with a will that says, I love my husband, I leave him everything? Or what if she gets in an automobile accident and somebody wins at courthouse lotto, and the money I thought was going to be there for Jimmy is lost in the lawsuit against my daughter? So we just need to sort of be mindful of a lot of the background that, that plays into the overall estate plan. I think that using the legal structure, especially where we're trying to preserve eligibility for benefits, using the legal structure to preserve eligibility through a special needs trust is the way to go. And how that interacts with Steve's piece is that I can create the legal framework. I can help parents with something called a letter of intent to guide a trustee in the administration of a trust. But what I find is, whether parents want to acknowledge it or not, most are like me and they have lifetime issues that their pockets aren't deep enough to address. And so there is no one that I work with in estate planning that's more in need of true financial planning than the parent of a child with a disability. Most of those parents have spent a lifetime's worth of money before they ever walked through my door at my office. Secondly, back to the needs are bigger than pockets are deep. I want parents to seek out a life insurance answer as part of the answer to funding a trust. Because I don't want parents to think they have to eat ramen for the rest of their lives in order to deploy enough assets to preserve eligibility, to preserve a reasonable lifestyle, and through a special needs trust. And so Steve can bring both the financial planning and the appropriate insurance products into play. And so interactively, I think that's sort of where he fits in from my view of the world. Does that help?
So the life insurance proceeds would be paid to the special needs trust as the beneficiary. Is that my understanding?
If you're at, yes. To my thinking, it needs to be paid to the trust, and at some point, any life insurance policy that's dedicated to the needs of that child with a disability should actually be owned by the special needs trust, which should be irrevocable from the outset. And the reason is, back to bad things happen to good people. If mom and dad own a life insurance policy, even if it's the perfect kind of life insurance policy, and they end up in a nursing home someday, that the cash value in that policy is the low-hanging fruit. The insurance company doesn't care about the child. They care about next month's payment, and they're going to say, liquidate the policy. We can't help that it's for your child with disability. Liquidate the policy, hand over the cash, and pay for the next month or three.
You mentioned the phrase letter of intent. What is that?
Every practitioner in this area has their own version of letter of intent. I liken it to the letter that my wife wrote to the babysitter the first time we went out. And it started out, we will be at Greenwood's restaurant, and left the number for the restaurant, which will give you a hint as to how old I am. I go upstairs to put on a tie, and by the time I come back down, she's on page 5 saying, and grandma in Oklahoma can be reached in an emergency, and telephone number. You're trying to put on paper all the information that's pertinent to that child's needs. It's fun to poke fun at things like that, but the reality is, if a parent stopped and thought for a moment, what information do you as a parent have that would be lost if you were taken out in the blaze of glory on I-95 next week? And who's going to be left to hope they can rediscover that same information? Instead of that vainglorious hope, why don't we just actually formalize the process and put it down on paper? As I said, everyone has their own template to approach this. I know I do. I'm sure Steve does. We all send our templates out to our clients. I think it's an important learning and facet of the overall plan that a parent needs to go through.
What is Go ahead, Shane.
I was just going to say, one of the questions that we had in was with regard to guardianship. So when you have guardianship, how does the guardianship play a role within the finances? And whether it's the legal framework or the financial framework?
Well, guardianship in Connecticut is different from guardianship in almost every other state. Guardianship in Connecticut is aimed at a minor typically, or is aimed at a child with profound disabilities. And it really is personal decision-making, not financial decision-making. In Connecticut, financial decision-making requires going to the probate court and asking that a conservator be appointed of that child's estate, the assets that they own. So that's sort of how we distinguish between the guardianship and conservatorship. In most states, it's guardian of the person, guardian of the estate, and you hold one or both of those roles, and that, along with the piece of paper with the raised seal on it from the court, gives you authority to act on your child's behalf.
I think that question related to the financial piece maybe is geared more towards how does the guardian or how does the person who's responsible for the money or the individual with special needs, how do they possibly access that money, and how is that money distributed for that person? And as Jim stated previously, when the special needs trust is set up, it's typically, although not always, but typically it's funded with life insurance. And when mom and dad pass away, the second one passes away, that trust is usually funded with whatever assets mom and dad have designated to go into that trust, as well as potentially a life insurance policy. Typically, the trust will have a trustee or two designated to use that money that is now in the trust for the benefit of that beneficiary, which is the child with special needs. So if the money in the trust is available, the trustee might then take that money and use it to buy this child whatever goods and services they need to give them the life that mom and dad wanted them to have. They typically would not hand that money over to that child with special needs, because if they did, then they would be disqualified from receiving whatever benefits they might potentially be receiving. Instead, what they might do is they might use that money to buy the child an iPad, or send them on a trip, or pay the rent in the apartment, or give them a gift card at a restaurant. So the trustee really is the one who is using the money in the trust for the benefit of that beneficiary.
You mentioned if you're rich, according to the state of Connecticut, what is rich? What's their definition of rich?
For SSI purposes, which is the first benefit that a lot of parents encounter, it's $2,000. And that includes the bonds that grandma bought and put in her safety deposit box that you never knew about. They will find out about them. The tracing is that good anymore. For almost every other benefit, the threshold is $1,600 of assets. So they're deploying a public safety net, but it's not very high off the ground.
No. So any more than $2,000 in a child's name could disqualify them from receiving some state benefits? Or
generally, yes.
$1,500?
Under our Medicaid program, there's what's known as waiver programs that will allow larger amounts to be earned or set aside, held. But for the most part, those are the numbers that most of our parents need to work with for the time being.
And SSI stands for Supplemental Security Income, for those that are wondering about these acronyms. And that's one of the major public benefit programs for people with disabilities, along with Title 19, sometimes referred to as Medicaid, and I think it's Husky D here in Connecticut as well. And why this is important is, as Jim just mentioned, there are these Medicaid waiver programs that are run through various state agencies, including the Department of Developmental Services, the Department of Social Services, and I'm not 100% certain, but I believe the Department of Mental Health and Addiction Services. And in order to be eligible for some of these programs, you have to be Medicaid or Title 19 eligible. And in order to be Title 19 eligible, you also have to be eligible for SSI in order to receive these benefits. And that's why careful estate planning is so critically important. I also understand that there are other financial products that can be used besides life insurance. And can either of you discuss the ABLE Act, which some people may or may not be aware of? It's relatively new, and how that might be relevant to estate planning. And
sure. So in 2016, President Obama put together a piece of legislation which allowed our children to now have accounts called ABLE accounts, where monies could be deposited into these accounts, yet these individuals with disabilities would not then be disqualified from receiving SSI, Medicaid, whatever benefits they were currently receiving. So remember, just a moment ago, we talked about having no more than $2,000 in assets. Otherwise, your child might lose their qualification for any of these governmental programs. But now with the onset of these new types of accounts called ABLE accounts, there was actually an account that could be set up for your child to receive monies that they could use during their lifetime. So the way these accounts work is you can set up this account for your child, or actually the child can set up the account for themselves. And you can set this up in any state that is offering these particular accounts. Connecticut currently does not offer it, but there are over 40 states that do offer ABLE accounts. I actually have an ABLE account for my daughter, Liz, that I set up in the state of Ohio. I can contribute into that account $15,000 a year, and it's considered a gift into that account. And she is actually allowed to contribute up to $12,490 of her earnings each year. So potentially $27,000 could go into this account. Now, within the account, the money that goes into the 520, the ABLE account, will grow tax-free. There is usually a small group of investment options which are available. So in Ohio, for example, there's 5 different investment options. So I've selected the one that's appropriate for our situation. And the money in the account that's either gifted by me or anyone else who wants to make a gift, to no more than $15,000 total, plus whatever monies Liz puts in through what she's earning, will grow totally tax-free and can be used to basically pay for many of her daily living expenses. Now, the nice thing about this particular account is that there's a debit card that comes attached with it. So while the money is growing tax-free in the account, I can move money onto her debit card that she can use at Target or Stop and Shop or wherever a debit card is used at Starbucks. And that's really the primary vehicle that she's using to spend money for all of her day-to-day living expenses. And it works out great. I can go online. I can see how the funds are doing in the ABLE account. I can see what she's spending money on. I can see when the debit card balance gets low. I can move money back onto the debit card. So I have total visibility to how she's spending the money, and I have total control of how that money is being invested. Now, there are limits in terms of these accounts, and the limits are that the money in the account can grow essentially to $100,000. If the money grows beyond $100,000, then there will be a suspension of some of the governmental benefits that your child or young adult may be receiving. So the government essentially says, listen, we're going to use this or allow you to use this for your child or young adult as kind of a working account that they can use to spend money on their ongoing expenses, but we're not going to let it accumulate to more than $100,000. And there's also a limit that varies by state in terms of how much total money can actually go into the account. So for example, in Ohio, the account that I'm in, I think the limit is about 480,000. So during Liz's lifetime, no more than $480,000 can be contributed into these accounts. So I think these accounts are terrific as a way for my daughter Liz to have money that she can spend and she can use for her own benefit. Now, there is a negative in these accounts, and they've got what's called a payback provision. And I'm going to let Jim comment a little bit on the difference between the ABLE account and a special needs trust, why you need both, and why there's a payback provision in the ABLE account, but not in the special needs trust.
Okay. The special needs trusts generally are divided since 1993 into two types of trusts. One type of trust is funded with other people's money, mom and dad money. And that's the traditional special needs trust. There's also, since 1993, a congressionally authorized self-funded trust or self-settled trust that holds the assets of a child with a disability only. Congress thought that it was a good idea to allow someone to qualify for benefits by putting their assets into the trust, and the pay to play there was that the special needs trust for self-funding had to have a provision in it that says the government got paid back for a great deal of the benefits that may have been provided over a lifetime. The ABLE account, 529A account, sort of extended that thought process and said, if we're going to create a trust that the child with a disability can contribute their own money to, it needs to have the same kind of payback provision attached to it. So this is a good place, I think, to have money that is to be used in a child's life, in and out money especially. It's not really the best place to accumulate wealth. Number one, you're not going to be able to accumulate great wealth. Not that for $480,000 or whatever the number is in Ohio isn't a lot of money in my world, but it's not a lot of money to address a life needs for a child. And more important to me is sort of the distinguishing factor between a parent-created special needs trust is that the special needs trust can own a life insurance policy, and the ABLE account cannot. And so some of the big funding that I'm relying on couldn't be done through the use of an ABLE account.
So one of the questions, which relates to what you've both been talking about, one of the questions we received from somebody watching today is that how far back does the SSI look? How far do they go back to see what's been placed in a child's name? And I also have the question that, let's say my son Jimmy has $3,000 placed in assets of his name, and I then take those and transfer them into the ABLE account. How is that viewed? So that question is to either Jimmy or Stephen.
Go ahead, Steve.
Well, in terms of the $3,000, the ABLE account could be set up, and the $3,000 could be deposited immediately into the ABLE account, and then the child could be walked into the Social Security office and apply for SSI and be immediately eligible. So there would be no look back in that situation.
if the child already had assets and then set up the ABLE account, or a child, how far back do the SSI look back into a child's finances?
They're typically going to look back 5 years.
5 years.
And or as many as 5 years. But even if there were something that came into existence during that term, as Steve's already pointed out, those assets, be it bonds that grandma had or money in an investment account or a custodial account, those monies can be cashed out and can be contributed thoughtfully over time into an ABLE account at a rate of $15,000 a year. So that would be the strategy for these outside monies that might be caught under the 5-year look back rule.
That's great.
Well, the money could also be spent.
Oh, you're absolutely right.
So, for example, many families might be paying for private school or tuition, and rather than paying for it with their money, they could use their child's money to pay for that tuition and then reimburse the child through making a deposit into the ABLE account.
What the look back period involves is a transfer of assets without consideration. Can either of you discuss the specifics of that? Because that is I think that's what this question is looking at, because the look back period will determine your eligibility. So if you've transferred assets without consideration, that may be frowned upon by either the state or federal governments, and therefore be a disqualifying an applicant. Could you discuss that?
In my experience, if the child has disposed of the assets prior to applying for SSI, they then will be eligible. So they'll look at the last few months of bank statements, and if that child goes into SSI, Social Security office, and applies, they will in fact be eligible. So they may look back 5 years to see what assets the child has held, but when they're applying for SSI, as long as there are no assets in that child's name, it's not going to be an issue. It's different than Medicaid eligibility in a elder care situation where there's a 5-year look back before Medicaid will allow that adult or that parent or grandparent to qualify for Medicaid to pay for the potential cost of a nursing home. To get SSI, as long as that child has no assets in their name when they're applying within the last month or so, they're going to be deemed eligible, and they will potentially qualify based on all the criteria for getting SSI.
What do you advise grandparents who want to leave bonds or money to their grandchildren in the context of what we're talking about this evening?
Jim, you want to take that, or you want me to?
I'm easy. Go ahead.
Well, first thing I would advise them is don't. That's the easy solution. So I would tell my mom, don't leave the money to my daughter Liz, leave the money to me instead. But unfortunately, she's going to say, but I love your daughter Liz more than I love you. So probably she would say, I want to leave Liz some assets instead of leaving them for you. Maybe she doesn't trust me. Maybe she doesn't trust my wife. So one of the things that Jim can do is he can set up a special needs trust, and it's called an inter vivos trust. It actually exists. We can go and set it up. We can go to the bank. We can put $1 in it, and it's there. It's got a tax ID number, and it's a living trust. And we can tell grandma and grandpa and my sister and the uncle and the aunt, we can tell everybody in the world we've got this trust set up for Liz. And if they don't want to leave the money to me, they just need to leave the money to the Elizabeth Ehrens Special Needs Trust, dated October 1st, 2020, tax ID 12345. And then that money will go into that trust, and then that child will continue to be eligible for whatever governmental benefits they're getting, because the alternative of leaving the money directly to that child is going to create a situation where the child could potentially lose those benefits, and then we'll have to essentially set up what's called a self-settled trust, which Jim can comment on. Jim, what would happen under that scenario if they accidentally got money from grandma and grandpa? How would you handle that?
Well, if it's more than $15,000, and so the ABLE account is out, I would go back to a congressional authorization in 1993. And that authorization is that a child with a disability can create a trust and can fund it with their own assets. And the assets that are in that trust won't render the child ineligible for need-based governmental benefits, or at least federal benefits. The state of Connecticut's got a couple of different ideas for some of its programs, but generally that's what happens. Grandparents have what I fondly refer to as a white heart and an empty mind. They don't know what they don't know, but they're trying to do the right thing. And so it's part of my job, part of Steve's job, to be sure that they understand. We created a trust for this child. Here's the name of it. Here's the date of it. Here's the taxpayer ID number. Next time you go see your estate planning attorney, be sure to add one simple addition to a sentence. It may say, to each of my living grandchildren, but what we needed to say after that is semicolon provided, however, any assets left to Jimmy won't be distributed outright, but instead will be left to Jimmy's Special Needs Trust, created October 1, 2020. And I think that's probably the best strategy.
So we've got we have a question here actually regarding Special Needs Trust. Does Special Needs Trust pay back the state?
If it's funded with other people's money, mom, dad, grandma, aunt, uncle, no, there's no payback obligation. I do review trusts periodically that include payback provisions in the trust that doesn't have any payback obligation. It's funded with other people's money. So if you have an existing special needs trust and it's got a provision that says pay back the government, then you need to have that reviewed again.
And let me just interject here, but the ABLE account does have a payback provision. So what's important to know is when mom and dad die and the special needs trust is funded, and now the trustee or possibly the guardian is out there and sees that the child with special needs has an ABLE account with a payback provision and a special needs trust with no payback provision, it would behoove them to monitor that so that the money out of the ABLE account is spent down first to zero before the money in the special needs trust is spent down. Because that way, when the child ultimately does die, the ABLE account will have no money left in it to pay anyone back with. Yet the special needs trust will have money in it, which will typically go to, in most cases, that special needs child's siblings and or maybe the children of their siblings.
Are there any special considerations when parents divorce that impact special needs planning?
Well, the only special consideration that I would say is that they have to realize that they may not get along and they may argue over a lot of things, but they do have this child with special needs in common, and they need to provide for that child irrespective of what they're doing against or with each other. And that's actually kind of interesting because Jim has mentioned a few times life insurance as a way to fund a special needs trust. And just to sort of address that through this question, because this is really an option. If you were to sit with me and we were to put together a plan and we were to determine that at the end of your life, we wanted to put $1 million into a special needs trust, one of the ways to do that might be to save $1 million and leave that $1 million to that special needs trust upon our death. But another way to do it would be to buy a life insurance policy. And a life insurance policy is going to cost a lot less than that $1 million. Now, one of the things, of course, that's a problem that people don't like to do is they don't like to spend money on life insurance. Life insurance is not inexpensive, especially when we want life insurance, which is going to guarantee to pay a benefit when we die, not necessarily a term life insurance policy, which might last 10, 20, or 30 years. We want a guaranteed life insurance policy that will pay at the end of our life, no matter what. What many people do is they use something called second to die life insurance. So it's essentially a policy where both the husband and the wife together are on the policy, and they both have to die for the policy to pay. And the reason we buy a policy like that is because it's a lot less expensive than buying a policy on each one of us individually. If we buy it on both of us together, it's going to cost less money. And when we think about it, when, of course, will we need that money? It's not when I'm gone, it's not when my wife is gone, it's when we're both gone that we need to make sure the money is there and available. Interestingly, even though we're getting divorced, my wife and I, we still can buy together because we have this common interest, which is this child with special needs. Even though we're divorced, we still can purchase together this life insurance policy, which will significantly reduce the cost of either one of us buying this alone. So in many cases, I've found that even under the case of divorce, that this is a great solution that's relatively inexpensive as a way to fund the trust. So that's a long answer to that question, but it's just a very unique situation that tends to work out very well for divorced couples.
I'll also point out that family law judges do seem to be quite willing to incorporate in the settlement agreement a provision that requires the creation and funding of a special needs trust for a child with a disability. And I've seen many situations where the funding is to be at a certain level to be fulfilled by each of the two parents in whatever shares it seems appropriate. And it can be funded either with a distribution from the estate and or life insurance. So there's a lot of doors that can be opened up during the divorce proceedings themselves.
We had a question from a person, is there such a thing as a special needs bank account that can be set up for a child, or does it have to be an ABLE account or a special needs trust?
It's got to be the ABLE account or a special needs trust. There's no special needs account of any sort beyond the 529A ABLE account.
There's another question here that says, if a grandparent set up a 529 for a disabled child, what can be done?
So a 529 potentially could disqualify that child from receiving benefits. One of the things they can do is they could use all the money in the 529 before they apply for benefits for the child. Another thing they could do is they could change the beneficiary of the 529 from the child with special needs to another grandchild. And finally, what they could do is they could roll the 529 plan into the ABLE account, but only to the extent of their $15,000 annual gift. So there are some strategies to resolve the 529 issue, but potentially, if there is this 529 account, it could be a disqualifier for getting SSI or Medicaid.
And that's why it's important to consult with an experienced financial advisor and a trust and estates attorney. So I'm giving a plug to both of you because the rules are complex, and the state is very aggressive in trying to recapture assets if they can when they have improperly drafted special needs trusts or improper financial planning. This is more of a question to Jim than Steve. I get a lot of calls. I'm a special education attorney, and you're a special needs trust and estates attorney. What is the difference from your perspective?
From my perspective, I am an estate planning attorney who helps parents focus on how to address the needs of a child with a disability after the death of the second parent, typically. I mean, there's a lot of coaching that goes on for benefits application and things like that, but that's not primary to my practice. You'll have to tell me about the special education practice, though.
And for the people that want to know what I do, I represent children with disabilities, sometimes young adults, but my law practice is primarily involving special education, occasionally Section 504 plans. And for the young adults, young adult issues at college or applications to state agencies like the Department of Developmental Services. I myself do not set up special needs trusts. I make referrals to people like Steve and to Jim Funnell, who are more experienced in the financial planning. So, but I get calls quite often, you know, people want to know if I handle special needs trust because I'm doing special education. There are some attorneys that do both, but I decided just to focus on one, not the other. Jim, you had mentioned trustees, and I was wondering, are there any special considerations for selecting a trustee? Are there financial costs involved with a trustee?
In selecting a trustee, I'll say in Connecticut, you're really limited to 4 distinct groups of potential trustees. The first group is family and friends, and that does not include a sibling typically, because if we put one sibling in charge of the pile of money for the child with a disability, and that sibling who's in charge gets whatever's left when the child with a disability dies, there's an inherent conflict of interest in the arrangement. Not that one sibling is going to take advantage of the other, but just the mere fact that it could happen means there's a conflict of interest and we wouldn't have them serve in that role. But turning to, in my world, my brother Bill, Uncle Bill could be the trustee of a special needs trust because he's not going to ever get any of the money. That's just the way my own estate plan is set up. So family and friends, professional advisors, attorneys or accountants typically. And when I say that, especially about attorneys, I caution that I'm not including the person that you're meeting with for the first time that day. You actually need a relationship with any professional advisor, and you need to be comfortable with them on a very personal level. So if the attorney you're meeting for the first time says, and I'll be the trustee of the trust, in my opinion, you should walk. But it's still a possibility. Family and friends, professional advisors, bank and trust company is the third category. That's not in the cards for most of the folks I work with. A bank or trust company, in order to exercise the discretion that being a special needs trustee requires, will typically require a very substantial minimum relationship. $1 to $3 million is not unusual. And most of my clients don't have an extra $3 million for the child with a disability. And there's a lot of banks that will give lip service to lower numbers. In my experience, they don't really show up. So you want to be in the world of private banking. This is a high maintenance job, being a trustee of a special needs trust, and it requires experience. And The people who can bring that to the table will get paid well for it. The last possibility is an organization in Connecticut named Plan of Connecticut, planofct.org. You can look them up. They're the only non-bank or trust company that serves as trustee of special needs trusts in the state of Connecticut. And it's a nonprofit organization. They do a very respectable job. I've volunteered there 1 or 2 business days a month for the last 25 years. I don't get paid for the promo for them, but as I said, they're very good at what they do. And there are a number of parents that I work with who have no one else to turn to. There's no Uncle Bill out there in the wings who could ever serve in the role of trustee. And so even if I wouldn't name them as trustee of a special needs trust, because I've got my brother Bill, and if he's not around, I've got my brother Richard. But for that last slot, the bold assumption being, if I'm gone, they might be gone too. That last slot, I might name Plan as the backstop trustee I've named in the instrument to be sure that I've got somebody of quality serving in the role.
That's a concern that a number of families I've met with over the years, that's their biggest concern, is that they don't have anybody. Most people would be their peers, and they're assuming, that they're going to live to a certain age and their peers will too, or their siblings, that they don't have anybody else that would be suitable to take on that role. So it's good to know that there's that organization in Connecticut. Thank you.
We had a couple of questions that were coming in. What happens if a grandparent puts money in a college fund and the child has special needs, but should be able to go to college, such as a high functioning autistic child? Will a CHET, which is, I guess, a college fund, disqualify the child from state benefits?
Go ahead, Steve.
Well, I was going to say, most likely it will, yes. Most likely it will. So what they would need to do is probably, and just because someone is eligible for benefits at 18 doesn't necessarily mean they have to go get those benefits at age 18. So what I would probably recommend is use that CHET money up to pay for college. And when the CHET money is depleted, then go and apply for those benefits.
We have another question. What happens if a child, quote, quote, has received an inheritance and the parents have either guardianship or conservatorship? Can the parents in that capacity of guardian or conservator move the inheritance funds into a special needs trust?
Only the type of special needs trust that Congress sanctioned in 1993, the self-settled special needs trust. It's often referred to as a D4A trust, just different words for the same type of arrangement. A special needs trust that can hold the disabled child's own money, but must include a provision paying back the government with whatever's left. That's your option.
And one question was, if the child dies, where does it, I assume the funding goes? Does that go back to the state? Does that go back to another beneficiary?
No, if it's third-party money, mom and dad, grandma, grandpa money, it can come back to family, 100 cents on the dollar. There's no payback obligation. So that's typically how we want to structure and administer the trust. As Steve pointed out earlier, if we happen to have 2 trusts, one that held the child's own money and one that was funded by mom and dad and grandma and grandpa, we're going to spend the one that holds the child's own money. The hobbled trust is the one that's going to be spent to zero first. Because if there's anything left in the other trust when the child dies, and there should be money left when the child dies, properly administered, the trustee of a special needs trust is sort of duty bound to never run out of money. It's the only safety net the child's ever going to have. So that money should come back to family as far as I'm concerned.
So you'd have a special provision in the trust that upon death of the beneficiary, the funds are distributed.
Yes.
Somebody had asked, are either of you familiar with the Chet College Fund that's set up, I think, through the state treasurer's office? Because the question was, can you use the Chet funds for non-college expenses, such as a transition program, say a vocational transition program or independent living transition program?
Definitely here, Steve.
Well, in the last tax bill, there was a lot more flexibility relative to the Chet 529 type plans. And previously, these plans could only be used for college. Now they can be used for college, they can be used for private school, they can also be used for room and board, tuition, books, computers, etc. So it's likely that this money could in fact be used to pay for the cost of a transition program, whereas previously it was unlikely.
We talked about the benefits of special needs trusts and trust and estate planning. Are there any detriments that parents or families should be aware of?
Well, that's a funny question, because a lot of times when I'm working with people, they say, you know, I just don't know if my child is special needs enough to do this. You know, they're just borderline, and maybe I should wait, and I just don't know if they're really special needs. And as Jim stated right at the beginning of this conversation, he believes that there should be a trust set up for every child, as do I. Because the truth is, my daughter, who's a typical child, I'm not so sure I would trust her with what she's going to receive as an inheritance. I would want to make sure that the monies that I'm leaving behind are protected from creditors, from ex-spouses, from predators. I mean, just because she's a typical child, that doesn't mean I don't want the money I'm leaving behind for her to be at risk of loss. And of course, if my special needs child inherits money in the special needs trust and does better than I expect, the trustee can always turn around to that child and say, you know, Liz, your mom and dad set this trust up for you because they were concerned that you would be able to properly handle the monies that are in there. But clearly, you've turned out to be a brilliant young lady, more than capable of handling your own affairs. And that trustee could, in fact, pull all the money out of the trust and hand it over to that beneficiary if they felt that that was an appropriate thing to do. So I tell families that I work with, there's no negative to doing this planning that I know of. It just provides additional layers of protection. Jim, what do you think? Any negatives?
Well, the only negatives I can think of are in the context of not following through. It's one thing to finally decide to do the planning, but there's a lot of work that only the parent can follow through on. It's not all legal, it's not all financial necessarily, but beneficiary designated assets. Every one of those assets in life, be it a retirement plan, IRA, life insurance, annuities, all of those assets need to be directed so that the child with a disability receives their share through their trust. And so we can do all kinds of great planning, but a lack of follow through can blow it all up very easily.
That's a very good point. And I think that you're both right. I mean, just if you're setting up a special needs trust for a child that has the disabilities, I think it's also very prudent to look into it for other siblings that might be in the household too. As you said, they could you know, they might need that support and guidance too, depending upon how much sums of money you're talking about, until they're a certain age as well. So I think it's very prudent advice for every parent to consider, particularly in this time of COVID. Who knows what's going to happen next?
It's true.
Again, taking that one more step, and inside of the special needs trust, we might create a trust for other children or grandchildren that might receive money someday. Mm-hmm. But it took me 15 years in practice of my 30 plus years to finally begin to meet the grandchildren that were coming through the door. And lo and behold, some of them had disabilities. Yeah. And they were in line to receive something from this trust someday. And in that context, we have the ability to add a provision to allow something called decanting to occur in the trust, just like decanting a bottle of wine. If we end up with money in a trust that doesn't have the right words, we can pour that money off to a new trust that has the right words, but we have to specifically incorporate that. So being a little forward thinking about that is also useful.
Well, the trust is very important because I don't set up special needs trusts, I have read, and there's a lot of stiff language, often quoting verbatim Supreme Court decisions, because they don't want the Office of the Attorney General to be able to invade the trust and grab the assets. At least that's my limited experience with special needs trusts. Is that correct?
Absolutely. The mere fact that you've got a trust for a child with a disability doesn't mean they're going to be eligible for benefits. Assets in an improperly structured trust can disqualify a child from eligibility just as fast as cash in hand can.
But this leads on to a question here, which we've received tonight. If a child is disqualified from benefits due to money for college, how does that child receive health insurance if they don't have it from the parents? Now they're 18 but don't qualify due to this college money. How can they pay for health insurance?
Well, I understand that the Supreme Court heard oral arguments today on the Affordable Care Act, so I hope that survives that legal challenge. That's one answer. I don't know if Steve or Jim.
Well, just sort of as an FYI, so typically, if you work for a company, your children would roll off of your health insurance, your group insurance provided by your employer, by age 26. Many health insurance companies will actually allow your child to stay on beyond age 26 if they have a disability. So in my particular case, so I have a 28-year-old daughter who's still getting insurance through my employer because I applied for a waiver which allowed her, she's not receiving benefits from Medicaid or SSI or anything like that. I just stated that she has a disability and they allowed her to stay on. Of course, and when I go on Medicare at some point in the future, I'm going to have a problem. And Medicare is 3 years away from me. So I've got her covered until she's 31. So the question is going to be what's going to happen then. So hopefully the Affordable Care Act won't be dismantled, and that might be an option to go out and to purchase insurance for her. It's possible, I guess my dream is that she'll have a full-time job with benefits. You know, she's got a minimum wage job that's part-time, but maybe it's possible she'll have a full-time job that would provide benefits. Or potentially, if she doesn't have a job and the Affordable Care Act is dismantled.
You could move to the UK.
You'll have to go to the UK, right? So it's a problem, and it's a big concern.
And we have time for one final question, and it's sort of an area that I can answer part of. For purposes of SSI, we have a medical diagnosis, but the student IEP, individual education plan, has a different disability category. Would the child still qualify for this benefit, meaning SSI? We have multiple definitions of disability. We have disability under Section 504. We have disability defined differently for purposes of special education. We have disability defined differently for purposes of SSI, because the Social Security Administration has what's called a listings of impairment. So the child might have one disability category for purposes of special education, but that may or may not impact their eligibility for SSI benefits, which uses a different definition. So you have to know what program you're applying for, looking at what their definition is. The listing of impairments, you can meet or equal the listings of impairments and be eligible for SSI or Social Security, or have the application denied, but that denial would not affect special education. Conversely, you could be eligible for special education and not be eligible for SSI, or be eligible, because there are two different federal definitions, two different systems of benefits. I don't know if Jim or Steve have anything to add to that.
No, I think you're absolutely on track.
So it's almost 8:15. I think this would be a good point in time to wrap up. I want to thank Jim and Steve for their participation this evening, and for all of those who asked some very well thought out questions. I hope the answers were equally well thought out and beneficial. Jane and I are keeping a watchful eye on what's happening in the state for schools. As I mentioned at the onset, some schools, not all, are closing or suspending the reopening or the return to full-time instruction. Several have announced closures through January, some for 2 weeks. We're watching what's happening at the State Department of Education and the U.S. Department of Education as it pertains to special education. We try to give the best possible up-to-date information and allow you to ask questions, and we are continuing to offer this series on special education with a roundtable discussion, topics like tonight dedicated to very specific topics of interest. So our next presentation will be on Wednesday, November 18th. We're going to have a special education roundtable discussion with myself, Jane Faherty, Jennifer Weitz of JW Advocates. And on December 8th, we will have Dr. Ronnie Sandler Cohen, who's a clinical psychologist, author, speaker, very well versed in the area of evaluations and independent evaluations in particular. As always, we welcome your questions during the webinar and in advance of the webinar. And to register and learn more about these events, you can check Jane's Facebook page at the Stamford Jewish Community Center. I might add that all of our contact information is in the chat section on the website, whether it's Jim, Jane, Steve, or myself. And you can register on our Facebook page and the JCC website and the Facebook page as well. So those are my concluding remarks, and I want to give an opportunity to Jane and our two special guests to offer some concluding remarks and thoughts. I'd
just like to thank Steve and Jim for coming tonight. I think it's been extremely informative, and this is a subject that we shouldn't push to one side, as sometimes distressing as it is to consider financial implications and you know, our life ending at some point. It's really important to make sure that we address it now and that we put the provisions in place for our children for their future. So as difficult as some of these conversations are, they're really important to have. So thank you, Steve and Jim, for coming tonight. And just to remind you to check out the JumpStar's Facebook page as well. We have some more informative events coming up, and we're going to try and do some social, virtually social activities for parents and caregivers of all ages. So Steve, you're more than welcome to join us too one evening, and you too, Jim, if you'd like. But thank you for coming tonight. It's been extremely informative. And just to remind everybody that you will be sent a copy of this recording after this webinar at some point later this week. And we'll share it going forward. So thank you so much for coming.
Larry and Jane, thank you very much for letting me participate. I enjoyed it very much.
Thank you, Larry. Thank you, Jane. I'm just going to say one final thought, and that is that peace of mind is what Jim and I are providing the people that we work with. When they're done with us, they walk out and they can relax, they can sleep well, they can not worry. And I know parents worry about what the future is going to be when they're no longer here. But what we give parents is peace of mind. And that's really, really a nice thing at the end of the day, is to have one less thing to worry about. And it's well worth the time and effort and energy to work with us, to get this behind, and to sleep better at night. Wouldn't you agree, Jim?
Absolutely. Well said.
Yeah, and I don't think your child is ever too young for you to start considering these things. There's no age at which you think you should do it. I think the younger the better. As Stephen just said, put your peace of mind at rest, and one less thing to consider going forward.
Right. Thank you.
Excellent advice, good points. And I think in this period of anxiety, anything that will reduce our anxiety is vitally important, because we are in unsettled times. So if we can at least resolve one problem in our lives, we can cross that off the list. So I want to thank Jim, Stephen, and Jane, and all of you who have been with us throughout this evening. And we will see you on the 18th.
Thank you. Bye.
Bye-bye.